All right, while you're getting situated, I'll just go over a couple things, mainly for those who might be listening from afar. So if you miss anything, feel free. I will repeat it if anything is needed. But we are here now in the matter of Hardman versus Hardman. First of all, I would like to let you know that the chief is recused from this matter, and so that's why I'm presiding today. And in his place, we are pleased to be joined by Judge James Blanche from the 3rd District Court, and we very much appreciate him being willing to step in and sit with us in this matter. I'll also just mention that the court recently became a court of 7 at the end of January with a new legislation that was passed. It's why we have 2 extra chairs up here. We will occasionally sit as a body of 7 when we have a challenge to the constitutionality of a law. But when we don't, we've adopted an order that allows us to sit in a division of 5. So you will see us in our normal, or at least our traditional constitution today is 5, but that's why we have 2 additional seats up here. I will, I guess, proceed and let you make your appearances now, and then we'll just talk a few additional items.
Good morning, Your Honors. Taylor Webb on behalf of petitioners.
Welcome, Ms. Webb.
Good afternoon, Your Honor. Ben Lusty on behalf of appellees, the Hardman brothers, John and Paul Hardman.
All right, and welcome, Mr. Lusty. Apologize for keeping you waiting today, first of all. And I know you both understand the clock and how it works very well, but it sounds like, Ms. Webb, you've reserved 5 minutes for rebuttal. Is that right? Okay. And we will just continue to ask questions if we have them. Feel free to go past your double zeros if we get you there, and you don't need to ask permission to continue. And we may end up giving one side or the other a little bit more time. That will just reflect the nature of questions we have and nothing else. So with that, Ms. Webb, if you want to proceed.
Good morning. May it please the court, Taylor Webb on behalf of petitioners. When this court makes a waiver determination as to whether a party has waived the right to arbitrate, the court first looks to whether that party has substantially participated in the litigation to a point inconsistent with the intent to arbitrate. To that end, I would point the court's attention to Addendum E of our opening brief. Candidly, I don't know how the court can look at a 33-page docket for a trial-ready case and conclude that that demonstrates anything other than an intent to litigate, not arbitrate. I think that's true of the brothers' conduct both before and after the filing of the notice of appeal. And I recognize that ordinarily this court does not look to post-notice of appeal conduct when making determinations on appeal. But in this context, it does, and it has. This court in Baker looked to the party's conduct post-notice of appeal, post-briefing on appeal after the case was submitted on argument, and the conduct that occurred after argument on appeal in Baker was the conduct that this court found dispositive of the waiver question. So I think it's not only appropriate, but I think it is perfectly appropriate for this court to look to the docket as it sits today with a trial-ready case after 3 years of litigation in the district court. And in fact, there hasn't really been any activity in the district court since June of 2004 when this case became trial-ready, because there's basically nothing else to do but go to trial at this point.
Can we talk about the standard of review?
Certainly.
And I understand your argument on ASC Utah, and I appreciate your attempts to finesse that to make it workable. And I also realize that you haven't actually asked us to overrule that statement in ASC Utah. But I'm trying to figure out how much leeway we have here with that, because ASC Utah didn't purport to overrule Chandler. So it seems like we perhaps just have 2 different statements of the standard of review. Is this court at liberty, even though you haven't gone through the Eldridge factors and all of that to technically overrule ASC, could we simply say, no, Chandler was correct, and that's binding, and the statement in ASC Utah was essentially not?
I think there's a couple ways to deal with that, Your Honor, because ASC didn't purport to overrule Chandler either. Mm-hmm. So I think that the way that this court can reconcile that is as we've described in the briefing, that if it is true that the district court truly looks to only the documents and nothing else, then I think a correctness standard as articulated in ASC Utah would be appropriate, and that's what we've argued in the brief. But our point is that when the district court looks beyond those documents, that there is some measure of deference entitled to the district court's determinations, and we think that that standard applies to us, but we also believe, of course, that we would satisfy either
I'm
standard.
going to
Isn't
give
the
you
doc-
some, so, can I just finish
Of course.
one thing?
Go ahead.
I'm going to give you some friendly pushback on that.
Sure.
Is it appropriate for the Court of Appeals or this court to review documentary evidence in the first instance if there are competing inferences that can be drawn from it? I mean, I certainly understand if the documentary evidence can only reasonably be construed in one way. But if the district court can look at it and draw one inference, and the appellate court can look at it and draw another inference, why wouldn't we defer to the district court as the fact finder?
Well, I think you certainly can defer to the district court. I don't know, I mean, I think ordinarily this does sort of fit in the same bucket as, a district court's review of a contractual provision in the first instance. If there's no extrinsic evidence of the party's intent, typically this court looks at that for correctness, and I think that's appropriate. But if this court wants to give additional deference to, like I said, I think that is appropriate when it's clear that the district court has not looked beyond the documents. And that's not what we have here, so I do think that deference is warranted for exactly what Your Honor is articulating, which is that there is more to the district court's determination here than just a plain cold read of a complaint that's filed. But I would also then point the court to the articulations in Turpin and Educators that when we're talking about a plaintiff as opposed to a defendant, the complaint honestly is all that you need. And I think that's a critical distinction that sort of gets lost in a lot of the discussion of the case law here. Is so much of this case law is dependent on when we're talking about a defendant, whether a defendant has waived the right to arbitrate after being pulled into litigation involuntarily, as opposed to a plaintiff who has voluntarily initiated the litigation by filing a complaint. And the case law is clear on that, at least from the Court of Appeals, that the complaint itself is all that you need.
But what if the complaint itself said expressly, this complaint is filed purely to get an injunction or pending arbitration? Then would the filing of the complaint itself still be per se evidence of an intent to litigate?
No, Your Honor. I think that the caveat to filing the complaint being dispositive is that the complaint needs to articulate if it is for something other than invoking the jurisdiction of the court wholesale, then it needs to make that very explicit. And I think that my opponent here has made the assertion in the briefing that it's really important it's really important that we have certainty and clarity on this point. And I agree with that. And I think that's why we've kind of articulated a bright line rule that would make clear to all parties that if you're going to seek anything from the district court and maintain your right to arbitrate, you need to be really explicit about that. And if you're the plaintiff, I think it's perfectly appropriate for the bright line rule to be that if you're going to file a complaint and invoke the power of the court, that you need to be explicit, that is done solely for the purpose of whatever your tangential remedy is, and here seeking the TRO, that it's with the intent to preserve the right to arbitrate. I know you had a question, Your Honor, and I feel that I have
That's
gone
just fine.
far.
No, thank you, Ms. Webb. So a couple of things on the standard of review. So we said in ASC that we review for correctness when the determination is based only on documentary evidence. Mm-hmm. Isn't that just shorthand for there was no evidentiary hearing and the court didn't make any credibility findings and things like that? Because if we're going to defer because the court is there, which is why we usually defer to the court, it's because the court is making credibility findings, not just like, well, I saw them in court and they were really litigious that day. Like, how is it supposed to judge whether somebody's intent to waive an arbitration based on the kinds of observations that you're talking about? Because it seems to me when ASC said that, it's basically just shorthand for where the court doesn't make any credibility findings or have an evidentiary hearing, then we're in just as good a position as the trial court is to do something like you were saying, to interpret the terms of a contract or to decide the import of what the filings say and that sort of thing. So speak to that, and then I have one more follow-up.
Sure. I think it's also problematic that there's not been evidentiary hearings in the other cases that go the other way on the standard of review. So in terms of reconciling that inconsistency, I think we have to do a little more.
It's an inconsistency either way, okay.
Right, and that it can't, it's not, something short of an evidentiary hearing can still get you to deference to the district court because there's still more than just the cold documents and the cold record, right? Because the court has had participation from these parties.
Yeah, but I'm just saying, how can it glean something from that participation?
Well, the parties participated in hearings, not just, filing documents before the court. And again, I think that in this case, we fit into that category, but even if the court were to determine that this does not, I think realistically, Your Honor, what the court needs to articulate to clarify is whether and when whether and when the district court has looked beyond the documents themselves. I think that's the clarity that would sort of resolve all of these inconsistencies without getting too far afield of all the precedent.
Right, that's helpful, thank you.
And did you have another question?
No, we covered it.
Okay, thank you.
If we're going to give the court deference in the way you suggested, should we require the court to enter more detailed findings then about why it's inferring the intent it is? Because it's not something we can really test, right, from the cold record and see whether or not we think the court has, if it's clearly erroneous or go against the clear weight of the evidence. I mean, how do we test then the court's assessment?
I think if the court wanted to articulate a requirement that the district court enter specific findings, I think that would be appropriate, but it certainly never required that before. And I think even when the district courts make credibility determinations generally, I don't think that this court requires the district court to say, I am making a credibility determination, I am determining that X party is more credible than Y. I think that's generally inferred from the fact that the court has accepted one party's version of events as opposed to the other.
I think that's a good point. I think the difference here would be potentially you are having the court make those determinations based on evidence that's coming into the record, right? Sure. You're having people testify, and then they're making findings about what they believe without necessarily having to say why they believed someone. Where here, I think the suggestion is maybe a little bit more like attorney's fees, where the court is kind of aware, the court has experienced it, and I think that's what makes these cases different.
Right.
It maybe calls for a different standard of review, I'm not sure yet, but at least I can see the argument, because it's not that the court's just judging facts that occurred outside the courtroom. Mm-hmm. The court's judging things based on its own experience in the courtroom with these parties. But I just wonder about how we make sure that the court's properly reflecting that experience in its findings.
And as I said, I think you can articulate a requirement that the district court make those findings. And I as a reminder, we were not the original appellants here, and my opponent here never made a challenge to the sufficiency of the district court's findings on appeal. So I don't think that's an issue. But again, I would just encourage the court to look through the docket. And as I said, you can look at the docket as a whole and find that it shows that there's an intent to litigate as opposed to arbitrate, but I think that's more than true of the conduct that occurred before the notice of appeal as well, and including before and after the filing of the motion to compel here, which this court again in Baker said is appropriate to consider conduct both before and after the filing of the motion to compel, because that still amounts to substantial participation, whether it's before or after. And here we have that in spades.
If we were to look at things that occurred, if we kind of look at those chunks of time, right? Should we at least cut off anything that's occurred after the motion to stay was denied?
No, Your Honor. And are you, I guess to clarify, well, the answer is no. Are you specifically referring to which motion to stay?
So I'm talking about the motion to stay that occurred after the appeal was filed, when I think there was litigation for about, 6 to 8 months, somewhere in there. Excuse me. And then the party came in and asked the court to stay the litigation. I think it was after the second brief was filed, or the appellee's brief was filed in the Court of Appeals. So is it fair to use that activity against the plaintiff when they ask the court for a stay, at least at that point?
I think it is, and here's why. Because because of exactly what you've articulated, is that motion to stay didn't come for over 8 months after the notice of appeal, after 8 months of continued litigation. And the reason that the district court denied that stay was because of exactly that, because there had been ongoing litigation. The district court denied the stay because it found that the plaintiffs had been sending discovery requests, opposing motions for fees, responding to discovery, filing a motion for extension of time, filing motions for additional TRO, filing 60A motions, seeking to extend discovery deadlines, seeking to amend the complaint, which was granted. So the district court's basis for denying the motion to stay was the fact that they had never sought one at any point in the 20 months prior or the 8 months since the notice of appeal. And beyond that, the brothers then did not seek Rule 8 relief from this court. I think that if the brothers had basically done everything they could and done it timely, for example, seeking a stay at the outset, and if the district court denied it, seeking relief from this court, and at that point they didn't get the relief that they wanted, then I think that at least demonstrates the intent to arbitrate as opposed to litigate, but failing to seek the stay until after the response briefs were filed on appeal, and I think that's actually the reason that they sought the stay at that point was because the response briefs on appeal took them to task for not having sought a stay, and that's when they decided to do it. But the failure to do that is relevant both to the intent to litigate and also the prejudice to the other party. But seeking a stay 8 months after after filing a notice of appeal and 20 months into litigation hardly demonstrates an intent to arbitrate. And if on the other hand you were you had sought the relief and were denied it, then obviously you've demonstrated your intent to the contrary and you are truly being forced to continue at that point. And so in that circumstance, and I don't know that it's appropriate, but that's certainly not the circumstance that we have here.
But can I just clarify, your first line argument is that when a plaintiff files a complaint and does not refer to arbitration, that's per se participating in litigation, evincing an intent not to arbitrate.
When the question is whether the plaintiff has waived, yes, Your Honor. I think it's different for a defendant, obviously, as the cases go through, but I think that's a pretty straightforward bright line rule that this court could follow, and to the extent there's any concerns about that being too strict or too harsh, I mean, we have the second prong of prejudice as a backstop to, an accidental filing a complaint, or I didn't realize that I filed the wrong document or something like that. There's always the backstop of prejudice. I think the court could also view it, if anything, as a rebuttable presumption that the plaintiff has demonstrated the intent to litigate, but I also think there's no downside to, really no downside to having clarity on this and making clear that what plaintiffs need to do to make sure they're preserving their rights, because it is their affirmative obligation to preserve those rights.
So this strikes me as kind of like waiving personal jurisdiction. Why we have kind of notice of special appearance, right? So you can come in like, look, I am not appearing in the lawsuit. I'm just here to do this one particular thing. So you're saying that's incumbent on them to say, hey, we don't really want to litigate. What we want is this. We want to litigate this TRO because that's not available in arbitration. And then once that's resolved, then off we go, one way or the other.
Right.
Then that's off we go. Would you say that that's an apt analogy?
I think that's correct, Your Honor. I think it's about the same context here. We have nothing more here than passing references to arbitrations, even in the request for TRO, where that the brothers point to as sort of maintaining their right to arbitrate. The proposed order on that motion references a TRO pending further litigation. There's maybe 2 or 3 passing references to arbitration throughout the proceedings up to the motion to compel, and in that same amount of time, there are countless references to litigation, ongoing litigation, resolving these claims through litigation.
And feel free to pass on this question if you don't know the answer, but I genuinely don't know, and I've just been trying to think, so I'm grateful for any thoughts you have on it.
Sure.
So other than trying to get a TRO to try to maintain the status quo pending arbitration, are there any other reasons for somebody to file a lawsuit instead of just going to arbitration, if that is indeed their intent?
Not that I'm aware of, Your Honor. I mean, off the top of my head, I can't give you a great answer to that.
I couldn't think of any. If you had any ready at hand, that would be.
But I also think that even if there are some other considerations that I can't think of or this court can't think of, that the ways to preserve the right to arbitrate are very clear, which is that you make that explicit to the district court and to the other party. And I think at this point, you can also initiate the arbitration proceeding. And if there's something in that proceeding that you can't get and that you do need from the district court, then you can go to the district court. And I would say best practice is still, even when you're going, if you've started the arbitration process, make your intentions clear if you go to the district court, no matter what. But I think that would be a little bit more clear.
If we adopted the bright line rule that you're suggesting, would it be fair to apply it in this case?
Yes, Your Honor, because that's the rule that the Court of Appeals has articulated the only times that it has examined whether a plaintiff has waived the right to arbitrate. And it's, to be clear, the plaintiffs here have done much more than just filing a complaint devoid of preserving that right. But even if that were the limit, I think that's perfectly fine to have applied, because that was in both Educators and Turpin, the court said that even looking beyond that was the district court was mistaken to look beyond the filing of the complaint itself.
Well, I think Turpin did say there was the filing of the complaint and nothing else to suggest a contrary intent. So I think at least in Turpin, the court would have been open to considering that. It wasn't suggesting that regardless of what other contrary intent was out there,
Certainly.
that if there was not a demand in the complaint, so to speak.
I should clarify that I don't intend for the rule to be, if you invoke arbitration in the complaint, then I think that preserves your right as long as there's sufficient invocation and not, again, just, a mere passing reference or something of the like. But otherwise, a complaint like we have here that mentions nothing about arbitration whatsoever, not even the existence of the provision, let alone an invocation of arbitration, would waive.
If counsel had included what it said in the TRO papers the very next day in the complaint, would that suffice, or would that satisfy your, kind of the bright line rule you're advocating for?
It's a little bit of a close call, Your Honor, because again, that's barely a passing reference in the document itself, and the proposed order attached to that TRO asks for a TRO pending further litigation.
But I
So-
guess the question is, what's the difference between a passing reference and the wholesale demand you're looking for? I mean, what is it that someone would need to say? Is this, we rarely like to say you have to use these particular words, right?
No, and I don't mean to suggest there's sort of magic words, but I think a plain and explicit invocation of the right to arbitrate, the preservation of the right to arbitrate, clarity that this complaint and any attending documents are filed solely for the purpose of seeking a TRO or what have you, and that they intend to preserve the right to arbitrate. And again, that by itself is sufficient, but here we've got plenty of conduct beyond that satisfies the waiver.
All right, thank you so much. Mr. Lusty?
Thank you, Your Honor. May it please the court, the Hardman brothers asked this court to affirm the Court of Appeals below. The brothers did file a complaint, and the complaint regrettably did not include the word arbitration in it. The motion for TRO that was actually dated the same day the complaint was dated, although appears to have been filed the very next day, did say, however, please maintain the status quo pending arbitration. And yes, it is true that the words of the motion for TRO did say pending litigation. Litigation and arbitration are sometimes regrettably used interchangeably in lawyer colloquial language. But it is clear from the words of the motion for TRO that the brothers wanted the status quo held for arbitration. We ask that the Court of Appeals be affirmed in all respects, that the standard of review be applied for correctness, and that this court held that the brothers did not waive the right to assert their arbitration. I want to get, first of all, to respond to a question that Justice Nielsen asked, which was, why would anyone file in the district court other than to seek a TRO? Sometimes counterparties to a motion to an arbitration agreement simply refuse to arbitrate. There's nothing in an arbitration agreement that's self-executing. People have to agree to arbitrate on both sides of an arbitration agreement, and as shocking as it may be, sometimes parties to a contract don't always follow through with the contract. Now, the Court of Appeals below found that the 2002 version of the Utah Arbitration Act, which has a specific provision for provisional remedies, which if sought by a district court, do not by themselves constitute waiver of the right to arbitrate, did not apply to this specific contract because of the date of the execution, which left the Rule 64 temporary restraining order as the sole remedy by which the prevention of the dissolution of the irreplaceable property
was going to be
right, could be prevented from further dissolution. Now, those findings by the Court of Appeals have not been challenged on this, so that's left as the sole procedural remedy, one, to stop the dissolution further of the properties, and two, to actually compel arbitration. Now, then the question may arise, and the members of this court may ask, then why did the complaint, not say in bright, neon letters, warning, warning, only to compel arbitration, and have all the further causes of action in it? Well, one of the things you have to prove in order to get a temporary restraining order is a likelihood of success on the merits. So you do have to show merits. You do have to show that, hey, these are things that we think we may be able to prevail upon. So you do kind of have to show everything that you think might be included in the claim. Now,
Didn't your clients also file a motion for summary judgment?
I'm sorry, Your Honor, I couldn't hear you.
Didn't you also file a motion for summary judgment or a motion for partial summary judgment as well?
They're filed yes, submitted no. And that was filed after the motion to compel arbitration had been denied. And so
Okay.
the filing of the motion for summary judgment, and that was filed, and this is important, the timing on this is it was filed May 25th, no, excuse me, yeah, May 25th, I believe. It was a cross motion for summary judgment, and it was technically deficient because it was filed in the same pleading as the opposition to the motion for summary judgment, specifically after the court had denied the motion to compel arbitration and ordered the brothers to respond, and then it was never submitted. So filed yes, submitted to the court, and asked to rule upon no.
Doesn't that show an intent to litigate, if that's what we're trying to figure out here?
Under Central Florida, it shows perhaps some, but not particularly weighty content. Central Florida says requests actually made to the court carry more weight than things not made to the court. So it was never submitted to the court. It was never asked to be weighed upon by the court. And this is where the 10th Circuit case that we cited, the Bosk or Bosca, it said both ways, said, yes, the complaint was filed and it was never served, although in footnote 2 that court said, not that we consider service to be the key thing. And that shows invocation of the litigation machinery, but not substantial invocation of the litigation machinery. So yes, perhaps a little bit of intent, but not the substantive or the significant intent that either Central Florida or Bosca, which applies very similar analysis to this, would carry. And I think more important, the fact that it's after Judge Walsh says, I deny your motion to compel, and brothers oppose the motion for summary judgment. And furthermore, the content of the motion for summary judgment, what the relief was asking was, Judge, undo the dissolution. It wasn't, and by the way, give us the particular distribution of assets that we want. It was undo what started all of this and not, therefore, give us the ultimate end game that we want, which distinguishes it from Baker versus Stevens. Now, Baker versus Stevens, well, it wasn't Dr. Stevens, it was a different doctor. Anyway, he filed the motion to compel, which was denied, and while that was up on appeal, he then said, oh, and by the way, district court, this plaintiff didn't ever designate expert witnesses, which is, of course, the death penalty to a plaintiff's med mal claim. So therefore, grant me summary judgment. And that's what this court on appeal said constituted waiver. You said, give me the walkaway motion, as if you hadn't even sought to enforce your arbitration rights. That's when you submit it to end game resolution, the entirety of the claim.
But why does it have to be end game? I mean, you were asking the district court in that summary judgment motion to give you relief that really the arbitrator would have been entitled to award, right?
I think the arbitration would have been division of the assets, final distribution of the assets, who gets what parcel, how much, how we.
I mean, that would have been part of it, right? But you couldn't have asked, that relief you were asking for in that summary judgment motion, you could have asked the arbitrator for that, right? It wasn't like a TRO type situation.
Respectfully, I'm not sure that that's entirely clear, to be honest. I think that perhaps it could have, but that's kind of in the realm of we're not entirely sure. And so I don't really know the answer to that question. But I do know that the motion for summary judgment that was filed but never submitted did not say resolve everything.
Sure. But what about now? I mean, the docket has 500 and something entries on it, right? It seems a bit
It does. And
absurd to go back now and to arbitrate. I mean, there's no question that there has been substantial invocation of the litigation machinery.
All after the motion to compel arbitration is denied and we have to litigate.
But you could have asked for a stay, correct?
There was a stay requested. It was requested late, but the stays are discretionary, and
Sure.
Meanwhile the claims are pending, and then it's how much do we have to do? Do we have to waive the claims? Do we have to say, okay, we didn't get to arbitrate, therefore we just give up this
I don't think so at all. I guess I just would expect a party to say, all right, then I'd like a stay. And if the court denies it, if it's a timely request and the court denies it, I'm not sure how anyone would hold that against you. But if it's not asked for in a timely way, it's a little bit hard to then conclude that there's no intent to litigate.
Yes, I see that, Your Honor. I think respectfully, though, once the request is made and it's repeated almost immediately, it's then stated continuously and continuously up until the time that the motion is dismissed, and then, denied. And then the court says, it's denied, now litigate. And by then, the litigation is pending. And then the, not technically interlocutory, but in the middle of the lawsuit, appeal is filed, and it's pending and on its track. I don't know, I think that's a reasonable amount of effort for the brothers to say, yes, we really do want to arbitrate. In the meanwhile, we've been ordered to litigate, and therefore we're going to litigate because we don't want to have to give up our litigation rights. And that speaks to what Central Florida said, the reluctant, unwilling, the things that you have to do because the rules of civil procedure say you have to do. And that something is, the idea that plaintiffs must be metaphysically treated differently to defendants speaks to two things that I think are worth bearing. One, this idea that in Turpin, the plaintiff was ipso facto waived because she filed a complaint, and the complaint by itself mystically constituted a waiver, misses half the story. Brittany Turpin was a plaintiff in a medical malpractice action. You don't just file your complaint in a medical malpractice action. There was the notice of intent in the pre-litigation part of the hearing. There was the participation in the pre-litigation hearing. There was the request for the pre-litigation hearing. There was the receipt of the certificate of compliance. There's 6 months of pre-litigation work that she has to do before she can even file that complaint that would not have been done before she can even file the complaint. That was part of the analysis in Turpin.
But don't you see a fundamental difference between a plaintiff who chooses to initiate the lawsuit, to invoke the machinery of the court, and a defendant who doesn't, but then we have to look thereafter if they've essentially waived their right to demand arbitration. But when a plaintiff files a complaint, that does seem to be fundamentally different than just being pulled into the lawsuit as a defendant.
It's one of the many facts to be considered, right? So that's one of the things that Boskin noted, is that we're not going to just treat them differently because they're plaintiff or defendant. It is a relevant fact to consider because the way you arrive at the motion to compel the arbitration is relevant. So Brittany Turpin and they're not quite the plaintiff, but the Educators Mutual, whoever had the right to, it was Baroque, whoever had the right to enforce that arbitration agreement. There was the filing of the complaint. Then there was just straight up litigation for a year, right? The litigation machinery was invoked. No indication whatsoever contemporaneously that anyone wanted to litigate in Educators. Likewise in Turpin, there's a whole year of litigation activity, if you count the pre-litigation activity, which is necessary to start the litigation train, that anyone wants to arbitrate. Now, in this case, we do have the filing of the complaint, yes, and the complaint doesn't say arbitration. Not ideal pleading, that's unfortunate. But contemporaneously, as the Court of Appeals put it, I think that's a fair word, the brothers say, and we do want to arbitrate. Please hold the status quo while we want to arbitrate. Now, the sisters say, well, we're not advocating for a bright line. But they're saying if you don't do it in the first pleading, then you've waived. That sounds like a bright line to me. And the problem with the bright line is it would enact a tacit repudiation of Chandler. Because Chandler says, evaluate all the facts of the case when determining whether there's been waiver.
But Chandler was in the context of a defendant, whether a defendant waived. Is that right?
That's true. That is true.
Can we talk a little bit about Chandler and the standard of review?
Yes.
I'm a little, I'm very concerned about the standard of review in this case. The idea that, I mean, what's at issue here, right, under Chandler is whether your client manifested an intent to litigate rather than arbitrate. And isn't intent just a fundamentally factual question?
Yes, it is.
So why shouldn't we, even if it is based on the cold record, if there's two different inferences that can be drawn, why wouldn't we defer to the fact finder? I mean, we do that on motions for summary judgment. We can say, we may say, look, the evidence itself is undisputed, like what happened, but there's two different inferences that can be drawn reasonably. And so therefore, summary judgment is inappropriate because it needs to be resolved by the fact finder. Which of the two competing inferences or more is reasonable. When we have a situation like that, why shouldn't we be required to defer to the district court as opposed to substituting our own determination of which inference is most reasonable?
I think that's answered by application of 11 factors, Your Honor. And so the first thing is, there's really, as Your Honor mentioned, no dispute over who filed what and when, what the words are. There's been no suggestion or no finding that the brothers were very angry or waveringly when they filed anything. In fact, I went back and looked at the meeting notes, the minute notes from the hearings. The brothers weren't even in attendance at any of these hearings. And so the question then is, if we go through the 11 factors, we look at things like, is there a common set of recurring factors? What's the policy? Is this the sort of thing that guidance can be given, even though there may be different facts that are going to articulate an applicable set or an applicable standard that district courts can apply in the future and that the public can understand in the future? So there are all the time factually varied settings and circumstances where the district court may be better placed, in a sense, to reach factual findings, but nonetheless are reviewed for correctness. So Thurman, whether a confession was voluntary. Levin itself, whether an interrogation was custodial. State v. Brake, whether a search was reasonable. AB, whether, a neglect finding. The district court.
I understand that where you're selecting the initial standard of review based on what, when it's a mixed question, whether it's more law-like or more fact-like.
Right.
I guess the proposition I'm challenging and would like you to respond to is this idea that regardless of whether we decide it's more fact-like or law-like, that even fact-like questions aren't entitled to deference if they're based on solely documentary evidence. I have a concern with that, like a institutional concern that we as the appellate court are not the fact finders. And that if there are two competing inferences that can be drawn even from documentary evidence, I'm not sure why the appellate court should be able to substitute its judgment for the fact finder. So that's my bigger concern, is this idea of, well, if it's just based on the cold record or documentary evidence, we're in just as good a position as the district court. We may be in just as good a position, but is that our role?
So a couple more direct responses then, Justice Hagan, to your question. First of all, I think if you look at the analysis that was done in, say, Central Florida and its progeny, all the arbitration waiver cases that purported to apply a deferential standard, they analyzed all the facts and then reached their own, basically those cases reached their own decision. And so they very much, although they said they were applying a deferential review, I would submit, were in fact arguing or applying a correctness review in any event. What makes this different is a couple things. One, there's a policy in favor of arbitration. So that gives this a different type of situation where this court has stated we favor arbitration. So that puts it in a different level where this court needs to take a second look. But two, one of the things that is going to favor a correctness review is that the lower courts and litigants need to see the common sets of patterns that would make for waiver and would not make for waiver on a threshold question. So we know what does and does not constitute waiver when we're trying to decide, are we going to arbitrate or are we not? Have we already waived or have we already not? Does this set of facts meet waiver? Do they not?
But wouldn't that argument just be that under Levin, because this is a mixed question, it is more law-like? And because we need guidance and it's just always a question of correctness, which is I don't think what ASC was saying. I think ASC was saying this is a factual question. It's more fact-like. But if it's just based on documentary evidence, we're not going to defer. Those seem like, do you see the distinction I'm drawing?
I do. I think that my arguments dovetail and are consistent.
Okay.
To follow up on that, isn't,
Yes.
you're kind of asking us to treat it like a motion to suppress, because motions to suppress are very fact intensive, but we don't give deference for policy reasons. But it seems like your policy reason of the trial courts needing guidance in how to apply these things is really no different than trial courts applying any other test that appellate courts come up with, right?
I didn't hear the last part of your question.
So, well, it's really, I don't see what distinguishes this situation from any other situation where we come up with a multi-factor test and say, okay, trial courts apply it. What is the policy? I guess it just falls back to favoring arbitration. Is that the policy reason?
That's one of the reasons,
Is that
and
your answer?
also having some certainty on a threshold question as to what forum is going to adjudicate a civil dispute, whether it be arbitration or litigation. That's going to be one of the others, because this is, will we be deciding this question before an arbitrator or before the district court? Because we haven't had a factual determination of the issues in this case yet. So yes, I always hesitate to speak about criminal matters having never practiced them, but I suppose it is like that, Your Honor, yes.
Okay.
Speaking just to one last issue that's relevant to the standard of review, an argument was made that the Court of Appeals has struggled with the standard of review on these questions. But that just hasn't been the case. If we look at Turpin, if we look at the court below in this very case, if we look at Livingston versus Finco, if we look at, well, an interesting application has been the Nearhan, I hope I'm saying that correctly, case, where the Court of Appeals looked at these issues and said, we're actually going to apply a deferential standard review where there has been an evidentiary hearing as to the factual questions because of that, and where there hasn't been, and where these other cases have not had evidentiary findings, we're not going to.
Was there a case where there was an evidentiary hearing?
Not in the arbitration context, but
Right, so I'm not sure the Court of Appeals is really, I mean, the earlier Supreme Court cases where they were giving deference did not have evidentiary hearings. And I'm not aware of one that's ever occurred in either court where someone has actually conducted an evidentiary hearing to decide evidence on what was happening in the litigation.
in the arbitration context, I haven't, and furthermore, in my survey nationwide in the state and the federal courts, I haven't found one either. And that sort of gets to Justice Zimmerman's dissent, frankly, in Chandler itself as to that very question, well, anyway, which is why I would contend that the correctness standard is the correct standard. Unless this court has any other questions, we'll submit on the briefing. Thank you, Your Honors.
All right, thank you so much, Mr. Lusty. Ms. Webb, when you're ready.
To counsel's point about the right to arbitrate sort of governing here, I don't think that it's accurate to say that the right to arbitrate is what informs the standard of review. I think the right to arbitrate here is reflected in the court's requirement, both of an intentional waiver and of the prejudice prong. I think the Court of Appeals had a little bit of conversation about whether the prejudice prong is even still good law given waiver in other contexts, and I don't intend to make an argument either way on that, but I do think that this court has explained in I think Central Park that, or in Central Florida, excuse me, that the most courts deal with the right to arbitrate being informed with informing the requirement of prejudice in the waiver analysis. So I think that's where that's captured here. As to counsel's point about the fact that, or the assertion that there was, that parties are sometimes unwilling to initiate the proceedings for arbitration, and that then requires them to seek relief from the district court. I think the answer to that is that requires parties to file a motion to compel. It doesn't allow parties to sit and wait and litigate for several months. If the other party is unwilling to participate in what they believe is mandatory arbitration, the relief that they're entitled to is a motion to compel that arbitration, not the relief of litigating for several months until things don't appear to be going their way, then seek to compel, and then never stay the proceedings until things have continued to go on the path of litigation.
Do you agree with Mr. Lusty that to seek a TRO in the district court, you also have to allege all of the substantive claims in the complaint, because part of assessing the merits would be a substantial likelihood of success on the merits?
I do think that you need to allege at least the claims that are relevant to the TRO that you're seeking. I don't know that you need a full-fledged complaint as if you were proceeding to litigation, but regardless, you need to make clear in that complaint that it is for the purposes of seeking arbitration, not litigation. And that's certainly not what was the relief in the plaintiff's complaint. There's a specific provision, non-waiver provision in the complaint, and the only non-waiver in that section is that the plaintiffs do not waive any right to amend this action to include derivative action pursuant to Rule 23A if during this litigation the facts support such claims. And then the prayer for relief first requests the injunctive relief, and then later requests both economic and non-economic damages to be determined by the finder of fact and for any and all other costs and damages determined during the course of this lawsuit. So if I don't dispute that you need to file something sufficient to seek your TRO, but you need to make clear in doing that this is for the purposes of seeking a TRO and not for the purposes of initiating litigation. And again, to that point, at best, there are passing references to arbitration up to and beyond really the motion to compel. But there are, again, countless references to litigation beyond those passing references to arbitration. There's in the complaint, there's in the proposed order on the TRO, there is additional language about litigation in the motion to extend the TRO. There is additional language. The motion that seeks the PI says pending, the title of that is pending the resolution of litigation. The body of that motion also references litigation, not arbitration. Same for the proposed order on extending the TRO. Same in the reply in support of extending the TRO. There's countless mentions of litigation and the outcome of litigation, not arbitration. So again, I think that at any point in this docket, the docket supports an intent to litigate rather than arbitrate. And I think that this court need only look to the complaint itself according to the case law articulated in Turpin and Educators. And I would note the court's language in Turpin, which specifically indicate the pre-litigation panel and conduct in that case was not actually relevant to the court's analysis on waiver. The court specifically stated that the district court's focus on plaintiffs' post-filing activities was misguided because the filing of the complaint, quote, by itself evidenced a clear intent to litigate her dispute and waiver of her right to arbitrate. It was the complaint itself. It was not the pre-litigation conduct, though I suppose that would also be relevant, but the filing of the complaint by itself evidenced an intent to litigate, not arbitrate, and the same is true here, Your Honors. Thank you.
All right, thank you both so very much, and we will take this matter under advisement. We do need now to take a brief recess so we can reconstitute the panel.